Alex here with a video on legal nuts and bolts. The topic here is going to be affidavits versus letters. If you want to know in detail what an affidavit is, please check my affidavits video. I really wanted to do this video because people need to understand that there is a difference between a letter and an affidavit. A lot of people in child custody cases will get some doctor or somebody to type up a letter. This is worthless, at least in Nevada. An affidavit is almost the same thing as a letter, and you can just get a declaration in lieu of affidavit. If you want to know what that is, please watch my video on affidavits. I'm not going to rehash that. It's the exact same thing, except it has an extra sentence at the bottom saying, I swear under penalty of perjury that everything I'm saying is true and correct. That's all it is, and that line is so important. A judge needs to see that sentence in there. Because the doctor, if somebody just gets a letter from like a doctor or a psychologist, how does the court know that that doctor or a psychologist has any clue that that letter is even going to be in a court case? A psychologist or a doctor or any other professional, they need to know that what they're typing up is going to be used in court. It's important that they know that because it's going to put them in that mindset of, I need to be especially careful of what I say in this piece of paper because it's going to be put in a court. And so once, any professional who reads that letter that you've typed up for them, or any professional that types up a letter for you that is told, by the way, can you please put at the bottom, I declare under penalty of perjury that everything I'm saying is true and correct. They know that that's an alarm bell for them to be extra cautious about what they're putting in that letter. And the only person who would be afraid of telling their professional to put that sentence in there is the type of person who's wanting them to just think, oh, this is no big deal. This is just something that they need for their boss or for insurance or something. So I'm just going to say whatever they want me to say. And then next thing you know, it ends up in court and the judge is considering it. That's unfair to the other party, and a good judge will strike that letter. Some states might be different. I hate to say it, but some states out there might say, you know what, a letter's fine. And if that is true, if your state is one of those that will just take a letter and consider it evidence, and you're afraid of being like totally exploited and run over in court, then I suggest you get a subpoena and order that person who typed that letter to go to court and testify. The reason I say this is because I have a great example for you. My friend had a very specific friend who was in a high conflict child custody case with a guy who had all kinds of psychological issues. And that guy who had his visitation suspended turned around and got a letter from his psychologist that he was going to see saying that this such and such a psychologist feel that my client would be able to heal better if he got to see his kids again. It was just a letter. That's all it said is I feel my client would be much better off and he would develop much better if he could see his kids. Obviously, this psychologist had no clue what he was doing or where that thing was going to end up because it ended up in court. Now my friend, what did she do? She asked me for advice, and I told her subpoena that psychologist because I bet you anything he has no clue how his letter was just used, and the guy, his client, didn't tell him all of these crazy, wild things that he needs to know. That's what she did. She subpoenaed the psychologist. He was ordered to appear in court. He went to court. He testified, and he found out that his client was convicted of all these domestic battery issues and had problems with his new wife. And as soon as the psychologist found out all of this new stuff that he didn't even know and that his paper was used in court, as soon as he found that out, he changed his answer. He told the judge right then and there, I had no idea any of this other stuff was going on. And I do not recommend, in my expert opinion, that visitation is resumed because my client hasn't been honest with me. I have no clue what's true anymore. And of course, she won. So there's a difference between a letter and an affidavit. An affidavit is more serious because it has a sentence at the bottom that says, I declare under penalty of perjury that the foregoing is true and correct. Actually, let me add, an affidavit is actually more than just that. It's actually signed and stamped and sealed by a notary public. A declaration in lieu of affidavit will just have that line at the bottom. For details on this, please watch my video on affidavits. I mentioned this in the beginning. I'm mentioning it again so that you know exactly what they are and how they work and why they're even used. So yes, please, if anyone out there is thinking that they're just going to get a letter and that it's going to be good enough, think again. Look into the requirements that your state has, and if an affidavit is required in your state, figure out how to type one up, or if you're lucky, maybe they have a legal department that will do one for you, and get that professional to sign it because you can actually attach it to a motion and it has weight behind it. And then your opponent won't be able to say, hey, that's not fair. That's just a letter. That professional probably has no idea that it's even in court right now. So anyway, with that, I'm going to end this video. If you have any questions, feel free to post in the comments below.